All right, this will be case D 566-884, the Mack case. Counsel brings to the record.
Morning, Your Honor. Melvin Grimes, bar number 12972 for the plaintiff, Lori Mack. She's present, located at counsel table.
You know, Mr. Grimes, I just, for some reason, I thought this was solely a custody case. It is a divorce case. So what I'm gonna do for today's purposes, because unless there's an affidavit of resident witness on file,
There's not.
I'm just gonna have you finish it up by summary disposition. I'm gonna have the clerk go ahead and enter a default for the record. This court on we have a bug problem, sorry. On October 2nd, the defendant was not present. The court granted plaintiff sole legal, sole physical custody. The defendant was not present on that day. The court advised that the court would send out its what we call secondary notice of the CMC conference, and that if the defendant did not show on that day, the court would enter a default, striking all of his pleadings and simply granting the plaintiff whatever she had requested in her underlying complaint. And so we will go ahead and do that. We'll enter a default. We do need an affidavit of resident witness, and then if you just want to submit the associated decree and her affidavit as well.
Do you need an affidavit in support of summary disposition, or?
I do. It's probably going to save us from canvassing her and going through it unless you want to do it today.
I'll do the affidavit in support. Your Honor, the one thing, and it's not in the pleadings, is sole legal. Based on the text message that was put on the record last time, we would again ask the court as part of the
minutes say sole legal.
Correct, but the complaint does not.
Okay.
So what we're asking is that temporarily, pending his motion, that the FMC agreement and that sole legal, sole physical be granted to the plaintiff until such time as he does that. That way they don't have to go back to FMC. He's obviously dealing with some issues right now, and if the court becomes convinced that he's fine, I don't think Lori's looking to do that permanently. It's just a case of, frankly, his conduct's been worrisome over the last month. Is that a fair way of putting it?
Yeah.
Okay.
He's there, he's not there, he's there. Kind of frustrating.
No, and we'll note for the record before that he actually, I just pulled this up because for some reason I thought it had to do with today's date. It was actually him who asked for an ex parte order, and we signed it, granting the continuance to the last court date that he did not show up on. So he's clearly familiar with the pleadings and that it's going on. I'll also note for the record that the 16.2 secondary notice that was sent out to him on October 2nd has not been returned by U.S. mail, which we do when we scan back in if it gets returned, and that's not the case in this case. So it's assumed that he's received it.
Okay.
So we'll grant your request that it be sole legal, sole physical.
Okay. Thank you, Your Honor.
All right. Have a good day. And let me add in there, because I'm sure you've my typical language that before he does file a motion with the court that are you going to be attorney of record or are you unbundled?
I am attorney of record on
Okay.
this.
I'm going to require him under EDCR 5.501 to contact you, see if you guys can reach an agreement. If you cannot reach an agreement, then I'm going to require that he, under EDCR 5. I believe it's 303 or 301, that he submit an order for FMC, and that the parties attempt FMC before he files a motion with the court.
Right.
Okay?
Your Honor, he has not filed an FDF or regarding child support. Is the court entering orders?
Do you know if he's working or not?
I honestly don't. He's just sort of, yeah. According to the text messages, he is working.
Well, let's do this. If you want to get from, I don't think we've done it within the last 6 months to a year. I think they change it annually. Whatever the amount that DAFS is using as Nevada average wage.
Correct.
If you want to incorporate and put that, you can do that at this point.
Okay.
And your client may want to start that process anyway. So.
And in doing that, every department is different, I just did this in front of, do you want the statutory language that permits the court to adopt that as the?
Yeah, I have to have that as the reason why I'm
Fair
setting it in that amount, that he's not here, we don't know, and because of that, we're using Nevada average wage.
Perfect, I'll cite the statute and the administrative code that allows it.
Okay,
All right, thank you, Your
have
Honor.
a good day.